my presentation was how it works, but what is interesting is how it can use, and because of that, we contact two researchers, one in South Africa, that is Mr. In a moment I will present him, and one of China, Canada, and she will present us because they are writing right now papers and they are working as academics. And first of all,
perhaps before we move, we have someone online who wants to say
maybe,
something. We could try to see whether it works.
Could you say, David, that at the end they can because
David, if you could wait, if you don't mind, we are going to try to give you the floor, but we will first pass the floor to Solomon, right?
Perfect, excellent. Okay, Mr. Solomon Okorley, his affiliation is from the Center of Private International Law in the University of Johannesburg. His current position is postdoctoral research. His area of expertise is, of course, private international law and international commercial law especially. He plans to be professor there at the University of Johannesburg, and he's right now finishing his research stay at Unitroid. He finished that a few months ago. Mr. Solomon will first talk about his own research, and then he will talk about why this case analyzer works, if it was for him usable or not. Solomon, could you hear me?
Yeah, I can hear you.
Perfect. Yeah. You have the floor. You can start.
Let me just intervene for a second, Solomon. So nice to see you again after a long time. I just wanted to express my gratitude to our partner universities at this point, which are, as mentioned already in the morning, the University of Johannesburg and the University of Montreal. Before it was McGill, but then Geneviève Sommier changed to the University of Montreal, which is much bigger. Without them, we couldn't have done this research. And we are very grateful, especially for gentlemen like Solomon, who really devote their time to these truly academic projects. This would not have been possible without both the financing of Swiss National Fund, but also the guidance of our partners, Jan Nels and Isa Fredericks in the University of Johannesburg, and Geneviève Sommier in Montreal. Many thanks to them at this point.
Okay, Solomon, you can start.
Okay. Thank you all for the audience, and also thank you, Prof. Gersberger, Agatha, and then Rorik for the opportunity. It's quite unfortunate I couldn't join you, but internet and technology has made it possible. All right, so I think that my presentation has been made easier based on the presentation that has been done thus far by Agatha and then Rorik, because they've taken us through the whole architecture so far as the use of the Dataverse is concerned and how one comes with information. And I basically had to use this architecture in developing my paper with the title The Potential Influence of the Hague Principles on Choice of Law in International Commercial Contract in Ghanaian and South African Private International Law. I must indicate that without boring us with much information, once you talk about the Hague Principles, we know that it's one of the soft law instruments that has been drafted or promulgated, and it's intended to facilitate the development and then the refinement of party autonomy so far as international commercial contract is concerned. So the main aim of my paper is to look at how the Hague Principles can help in developing the private international law of Ghana and then South Africa. And the reason for this angle is the fact that one of the aims of the Hague Principles is to help in the development of the private international law of other countries. So the question is that in what way can the Hague Principles help in developing the private international law of Ghana and then South Africa? So in terms of a brief overview of South Africa's private international law, it is one that does not have its private international law rules codified, but then it is based on the Roman Dutch law as well as the English law, and there are instances where we've had domestic constitutional values like, let's say, Ubuntu coming in to influence the judgments of various courts that sit on cases. Now, in terms of Ghana as well, Ghana does not have a comprehensive instrument, or Ghana does not have its private international law rules codified. It usually has to base on usually English case law, and case law also becomes the principal source of law when it comes to cases that has to do with private international law. And I must say that judicial decisions on private international law is really scarce when it comes to Ghana's jurisprudence, when it comes to private international law matters. So you could see from how the country report on code gives you a brief overview of Ghana's position when it comes to its private international law matters. Now, for the purpose of this presentation, I have picked three aspects or three issues with regards to private international law matters that I would want to look at the two jurisdictions, that is Ghana and then South Africa, and then look at it in line with the Hague Principles. So, for instance, if you look at the issue of choice of law, that is you being able to make a choice of law for different parts of the contract, which we all know to be the passage. If you look at South Africa's position, South African PIL authors are of the view that, well, you can choose it. However, case law is also of the view that there is a restriction on whether you can choose a law to govern different aspects of the contract. In Ghana, there isn't a case law, there isn't a data when it comes to this subject matter. However, if you take the Hague Principles, the Hague Principles makes it clear, pursuant to Article 2.2, that the parties can essentially do that. Now, when we talk about choice of non-state law also, you would realize that when it comes to South Africa's private international law, it is unclear whether commercial parties can choose non-state law and incorporate it into their contract. With Ghana, there hasn't been any decision that has been taken on that. However, if you take Article 3 of the Hague Principles, it tells you that yes, parties can choose non-state law so far as their choice of law options are concerned. When we come
Solomon, could you put your presentation in presentation mode so that we can see the whole picture of your presentation? Is that okay? In presentation mode.
Right hand side, at the bottom of the right hand side, this little screen icon. Yes.
Okay.
Thank you.
Perfect. Thank you.
You're welcome. All right. So if you come to the issue of whether parties, after they have chosen their law to govern their contracts, whether they are at liberty to modify that law that they've chosen, and whether they would have to take cognizance also of whether third parties might be prejudiced by the modification of the law. If you come to South Africa, again, the position by the South African court is unclear because there hasn't been any case law decision on that. Likewise, in Ghana also, there isn't a data when it comes to that. However, if you take Article 2.3 of the Hague Principles, it makes provisions for that and makes it clear that parties are able to make modifications, and again, they have to ensure that the rights of third parties are protected. Now, the main aim of doing this analysis is to point out the fact that Ghana and South Africa position on these matters are unclear, and once it is unclear, it goes against the tenets of law that we know that the two tenets of law is one of predictability, one is certainty. So if there are areas of law when it comes to commerce that at the moment it is unclear as to what's the position of the law. It becomes very problematic so far as its implementation is concerned. So that is the reason why I had to look at this three areas of three issues when it comes to law. Now, the question is that how did the database help me in this particular research that I did? Now, one of the importance of the database is that it enables you to do for you to have a comparative judicial reasoning, whereby having access to the database, you are able to look at what is the position of different jurisdictions on this subject matter, so that, for example, if you are a judge or if you are even a scholar and you have to, for example, you are a judge and you have to make a decision, at least the database platform would give you an overview as to what is the practice that is happening in other countries, especially buoyed by the fact that Ghana and South Africa, when it comes to some of these issues, there isn't a clear position on it. Now, one importance of the Hague Principles is to lead to the reform or development of the private international law of countries. So again, with the database, it gives you empirical evidence of what has been the practice in countries, so that legislators, in their attempt to develop their law, that becomes more or less like a source for them where they can get to for example, they can get data to which would help them in their decision making. So for instance, if you go to the database, when I was doing my research like this, when it came to the matter of, for example, non-state law, I had to look at what is the position of Switzerland on it, and I saw that, for example, when it came to the passage, Switzerland allows it. When it comes to modification, it is allowed by Switzerland. So in that instant like this, when it comes to legislative reform, at least you would have a legal system to look at, and I had to look at some legal systems as well that do not practice it. So for example, when I again went to the database and looked at a country in the north like Algeria like this, if you look at Algeria, they don't allow for the passage, they don't allow for modification, and again, they don't allow for the choice of non-state law. So again, once you have access to all this information, it will enable you to make a more informed decision as to what should be the approach that Ghana should take, or what should be the approach that South Africa should take. And perhaps finally, because of time, the other thing that the database does for you is that, for example, if you are, let's say, a businessman, you are somebody into international commerce, having access to the platform would also enable you to get some information that, for example, if you have to draft a contract, you will know that, okay, well, I am maybe a business partner from, let's say, South Africa. I'm dealing with somebody from, let's say, Ghana. And based on the Ghana system, maybe the law does not allow the law does not allow commercial parties to have non-state law incorporated into their contract. So it means that at the point when the two of you are entering into the contract, you would make sure that you will not be tempted to choose any non-state law to be the governing law of the contract that you have entered into. So in summary, the database platform has been very helpful so far as the development of my paper, which has to do with the influence of the Hague Principles with respect to South Africa and Ghana's private international law is concerned. Thank you.